I'm Cynthia Rowland, and I want to welcome you to EO Radio Show, episode 48. I'm happy to have my colleague Nate Garhart back for a chat today about artificial intelligence, that is, AI, and what nonprofits need to know when using or being used by AI tools. We seem to be in the midst of an explosion of conversation about AI, what it can do, who is using it, how it is being used, how beneficial it can be, and how harmful. Today, I'm happy to have Nate back to talk about these evolving legal issues. This area of the law is just beginning, and most of the law has yet to be considered, so we don't have a lot of answers. We'll talk about some basic issues, but there are many more issues that we won't discuss, and even more issues that we don't even know yet will be significant. So with that in mind, here are some considerations that clearly will be part of the legal discourse among nonprofits and their advisors regarding artificial intelligence.
Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here.
I'm pleased today to be joined by my colleague Nate Garhart. Nate is an attorney at Farella whose work is centered on intellectual property issues, and as a key part of his practice, he works with clients to minimize the legal risks related to their branding, advertising, and publicity strategies. Online, he counsels clients on internet issues and e-commerce topics. He drafts website terms of use and privacy policies and helps clients comply with the laws of the United States and Europe. Welcome back to the show, Nate.
Thanks, Cynthia. It's great to be here again. And I think this is going to be a pretty fun subject to talk about. Yeah,
it seems like AI is in the news and talked about constantly. There's webinars for nonprofits from every potential angle, just about at least once a week, if not more than that. So I know it's a super hot topic. And what I was hoping we could do today is kind of touch on the main categories intellectual property law that we have to think about when we think about this emerging area of artificial intelligence. Let's start with the first concept that I think of with intellectual property, which is copyright laws. Orient us here to how copyright laws are going to have to react, or maybe how they react to this new concept of artificial intelligence.
Yeah, so there's two issues to think about here, two big issues. The first is who owns what's created by AI? And a second issue is, if you're using AI, do you need to be concerned about infringement because of the way AI works? And so let's talk about that second one first. The way AI generally works, these large language models that we're seeing, such as ChatGPT and many others that are coming out now, is they're trained by taking in a lot of data from the internet. Possibly the internet at large. They may crawl the entire internet, whatever that means, but they may crawl the entire internet and just collect information and learn from that information. And so when they're crawling the internet and taking in this information, they're making copies of it. They're using text, articles, etc. Code. They can actually pull up programs and enter those programs into their brain, if you will. They'll collect images, they'll collect music, videos, everything that's on the internet. The issue is that some of those things out on the internet that are publicly available are protected by copyright. So the question is, when AI makes a copy of this stuff, and it may be a temporary copy, but it is necessarily copying it, and when it does so, is such copying a violation of the copyright owner's rights in that material?
So for our nonprofits, that works both ways. We have our reports and our copyrighted materials on our website, and maybe we use an AI tool and gather information from other people's websites. We got to look at both sides as a nonprofit.
Exactly. There are lots of issues here, and it gets very complicated. But one of the things that copyright attorneys are focusing on right now is whether this training that's undertaken, does that amount to copyright infringement? And if it does, is there a defense to it? And the answer to the first question is very likely yes, it is copyright infringement. When you're making an unauthorized copy of something, it likely amounts to copyright infringement. But that doesn't mean that the owner of the AI that's doing it or the company that's employing that AI is necessarily liable for that copyright infringement, because there is the concept of fair use. And fair use is a defense to copyright infringement. It basically says, yes, I infringed, but I have an excuse. And the excuse is fair use. Fair use is pretty complicated, and we haven't seen any case law on this yet. But most commentators believe that training AI will fall into the protected category of fair use and will be permitted. That is, a user of AI that makes these copies for training purposes will not be liable for copyright infringement. Problem with it is that it's not an easy out. If you were to get sued for copyright infringement based on the fact that your AI is scooping this stuff up for training purposes, you couldn't get out on a motion to dismiss. Fair use is a very fact-specific analysis, and so you'd have to get pretty into litigation before you could get out on the fair use defense. And so it could be expensive. So it's really not a simple answer at this point. It's not a very satisfying answer at this point. But as the case law develops, it may be that these suits don't get brought exactly because they are going to be seen, this action is going to be seen as fair use. But this is the kind of thing that we need to see develop. We don't have any cases out there yet on which to base any solid recommendations or predictions.
Let's think about the output, though. I mean, it's one thing to crawl the internet and scoop up all these other works and add them into your model, which I think is not what most nonprofits will do. I know there are some nonprofits that are developing the AI tools, but as an example, one of our recent podcast episodes, we used an AI tool to take our transcript of what we said and generate an article. Now, that was our own work, so it wasn't infringing. But you can see how that would be very tempting to say, this is a great thing that I found on the internet, ChatGPT, turn it into something shorter, turn it into something longer. So how do we think about the output when we as a nonprofit want to use one of these tools to create a summary or a brochure or a compilation of useful information?
Yeah, that's a great question. And the first thing I would say is that nonprofits and all companies should avoid saying to ChatGPT or any other AI system, make another version of this article. That will necessarily be copyright infringement without a fair use defense if you don't have authorization to do so. So that's a start. But it's more complicated than that, because you may just say to ChatGPT, well, first you'd say to yourself, this is a great article on the subject of AI and nonprofits and outputs and protecting outputs. So you say to ChatGPT, instead of rewrite this article or rewrite this podcast or create an article out of it, you just say, tell me about the law concerning outputs and AI and nonprofits and anything else you want to ask it. And ChatGPT spits out this, what turns out to be, in your opinion, a very fantastic summary of what's going on out there. The concern is that ChatGPT creates these things by looking at other articles on the subject, looking at other information on the subject. Hopefully, it gets such a broad understanding that it creates something that is not really a copy of anything, but instead takes information and then synthesizes that information into new expression. But that's not necessarily always the case. And I'm using ChatGPT as shorthand. I don't know anything about the programming of ChatGPT. I'm just using it as shorthand for these kind of AI systems that we are currently working with.
That's the LLM, the large language model, means the same thing. Right.
Exactly. And so it doesn't necessarily create something that is new expression. It may just find limited resources and spit out something that actually has big chunks of information directly taken from a given article. There was a recent case that's pending where a AI system was asked to create an image, and it created the image, and an owner of certain copyrighted images noticed that this image that was posted by the company that requested it from AI, noticed that this image had a lot in common with a couple of their images and really was just an amalgamation, in their opinion, as they allege, of a couple of their images. And so it wasn't something new, it wasn't new expression, and they're alleging that it's copyright infringement. So there is that concern out there. The question is, how do you avoid it? And that's a tough one. That's going to be one that we're going to have to wait and see, because obviously the company that asked AI to create this image, they didn't go and scour the internet and make sure that it didn't infringe on somebody else's picture or look like somebody else's picture. And so how do you even know what it's doing? And the answer is you don't. But I would suggest a couple of things. First of all, the market's going to weed out some of the issues, because models that do this, AI systems that do this, or are more likely to do this, are going to become less popular. They're not going to be as marketable. So the market will help with that. The other thing is, you want to look at any system you're using. You probably use it under an agreement with the owner of that system, and look at the terms that accompany the system. So in those terms of use, they're going to make certain representations and warranties. To the extent you're negotiating with that owner of the system, you may want to push them on reps and warranties concerning infringement. They should have faith in their product, and they should stand behind it. And so you'd want reps and warranties, and then indemnification in the event that the system does infringe somebody else's copyright.
So we'll put links in the show notes to our previous episodes on privacy policies, terms of use, and copyright laws for nonprofits, because we won't have time to go into all that really deeply here. But as you mentioned, terms of use, I'm like, I never read those, and those are like boilerplate. And unless I'm doing something that's worth a lot of investment, let's put it that way, from my nonprofit, this seems like it's just a morass of issues. But anyway, I digress. I worry about the nonprofit's liability and how to avoid liability. And for so many nonprofits, just calling a lawyer means you don't want to do it, because it gets very expensive to defend, right?
Yeah. And let me touch on one other aspect of this, and that is, again, your example was great. So you have ChatGPT create an article for you, and you post it on your website, and you think it's fantastic. And then 2 weeks later, you see that another nonprofit that you don't really align with, you have issues with for one reason or another, has posted your article without any attribution, has just posted this article on their website. And somebody jumps out of their chair and says, this is copyright infringement. Well, you have a little problem there, because what's clear at this point already is that, at least under current law, output created by AI is not protected by copyright. In most countries in the world, this is pretty much worldwide with a couple limited exceptions, but in most of the world, and definitely in the United States, human authorship is required in order for something to gain copyright protection. And so if you do use ChatGPT or another AI system to write content for you or create images for you, those images and words can infringe somebody else's rights, but they are not themselves protectable as a copyrighted expression, because there is no direct human involvement. Now, how can we get around this? How can we get some protection? Well, you can revise it, change the article, add your own expression, human authorship into it. You'll only get protection for those specific changes that you make, but you can do it in such a way that it gives you, enough protection that you would be less concerned about having no recourse if somebody else posts this entire article. That's probably the best way to do it. Other way to get protection for it is in your own terms of use, to include provisions that basically disallow others from using your materials. Now, that's not necessarily going to save you. First of all, you'd have to enforce, and that's true with copyright as well. But secondly, if basically what you're doing is trying to create a contractual provision that creates copyright, that won't be permitted by the courts. It will be preempted by the copyright law. So that's not a surefire way to protect yourself, but I think it's worthwhile to have it in the terms of service just for the chilling effect alone.
Any other copyright points that we want to talk about, or should we move on to right of publicity?
No, I could talk about this copyright stuff nonstop, but
I know we could go on. But considering our time constraints and the attention span of most listeners, let's shift to right of publicity. That's first of all, let's define that. I don't think we talked about publicity rights in our previous episode, so it's another facet of intellectual property law.
Yeah, so right of publicity protects individuals' rights to control their name, their voice, their image, anything that's identifying them against unauthorized use for commercial purposes. First of all, this is an animal of state law. There's no federal right of publicity, so you have to look at specific state laws. California, for example, has such a law. New York has such a law. Tennessee, with its recording industry, has that kind of law. This is where they kind of were born out of, was to protect celebrities' rights in their own name and voice, etc. But they do expand and cover all individuals. Some of the laws cover all individuals against having others use their persona for commercial purposes without permission. And AI systems just don't consider those protections. So when you use AI to create something, it may create something that infringes somebody's right of publicity. This is very similar to the issue with copyright infringement, and it's just the kind of thing that we have to understand is out there, and that it's something you would want to look at the terms of use, terms of service that accompany any AI product you're using to try to get as much protection as you can against liability for anything that happens in connection with that. And I would note really quickly, commercial does not mean for profit. The fact that you're a nonprofit doesn't mean that your work is non-commercial. So it's something that nonprofits have to be aware of as well.
Why do we care so deeply? I guess I know why I care about someone using my images. How else does this come up in the nonprofit world? I mean, maybe they're not using it for, to make money, but they're just using my image or voice in their work product.
Yeah, so let's think about, you're a nonprofit that focuses on
Save the whales.
And that's great. Save the whales.
Right. It's always good. Nobody argues with that one.
You use AI and you create an image and an article that talks about, the latest in efforts to stop whaling and other issues that are harming whales. Well, your AI wanted a picture of a fisherman, wanted to create a picture of a fisherman, and it did so. And it happened to use the image of somebody who actually is a fisherman and incorporated that into the article and image that it creates. And it actually looks pretty much just like this actual fisherman who's out there living their life and making their income through fishing. That person may have a real concern about being shown on a Save the Whales website and flip it. I mean, maybe it's a fisherman's website and there's somebody from Save the Whales whose image is used on their thing that they spit out. You can see how somebody could be very upset because it seems like they're being associated with something that they just don't agree with. So I think that's, in my mind, how it would most likely come up, especially if the person is a celebrity, obviously. They're more likely to hear about it and see it. But you can imagine the situation where it comes up for any given entity, nonprofit or otherwise.
And this might be too off topic and maybe we save it for another episode, but I'm thinking of the layers of information that's out there. So my nonprofit has its own website with its own terms of use, and I can call you and say, how do I tweak this to protect on our images and our work product? But our nonprofit also has a Facebook page, an Instagram page. Do I have to go read those terms of use? Is that going to add another layer of complexity to what a large language model thing can do with my images that I also put on my Facebook page?
Oh, now that's a great question. That's looking at what are you doing to prevent others from using your images and materials that appear? And I would say, yes, you're going to start with the Facebook terms of service. That's going to tell you a good bit about what's permitted because you don't control those. Now, Facebook will tell you very likely that you own the copyright in all of the things that you post on your Facebook page, but it won't answer the question of, are you authorizing others to use it for any purpose? It may answer that question, but just the fact that you own the copyright doesn't answer that second question. And so, unfortunately, you're going to want to take a look at those terms of use, and you're going to want to take a look at the terms of use of any AI you're employing. So there's a lot to look at. No question about it.
It boggles the mind. So let's leave that as an open area for development, one of those areas where we don't even know how deep the issues are going to be.
I would suggest one thing, and that is perhaps you could use an AI system to review all of these contracts for you and get some basic information. Don't rely on it wholly, because remember that AI is not an attorney.
Yeah, exactly. And apparently takes some liberties sometimes in making things up.
Certainly does.
But it's going to be evolving. I imagine this stuff is going to have, maybe a year from now, we can do an update. I think that's a good segue to privacy. Privacy policies on our website as a nonprofit, as well as thinking about the privacy policies on other websites that we might use as source material. So orient us on the privacy policy or privacy issues.
Sure. So what we usually think about with privacy when I'm talking to nonprofit clients is their privacy policy. And what does your privacy policy do? Well, it identifies, among other things, how you collect information, what information you collect, what you do with that information, and who you share that information with. The concern is that AI tools that you implement can take actions that make your privacy policy statements untrue. And that's the thing to be concerned about. So an example of that is let's start with the inappropriate collection of personal information. So usually in a privacy policy, it says, we collect information that you provide when you sign up to receive our newsletter. We collect financial information when you make a donation to us, things like that. And you list out what you've collected. Well, you may, for marketing purposes and for building your database on your donors, etc., you may use AI to fill out more information so that you can be more responsive and more directed toward your donors. So the AI tool may actually go out on the internet and find lots more information about these people. Well, that's great and helpful, but now you've collected more information about people, more categories of information than you have disclosed in your privacy policy. And so you have to be concerned about that. Now, how do you remedy that? You control the AI and you say to you determine what the AI is going to collect, what types of things it's going to collect, and then you include that in your privacy policy and make it clear that you'll have this other information as well. So adds another layer in drafting that privacy policy to make sure that it dots all the I's and crosses all the T's on what you're collecting. You then have to look at, how does AI use the personal information? So, for example, if you are using AI to make some grant decisions, you have some small grants that go, to many people. And so rather than spend a lot of time, you have AI that looks at certain categories and characteristics and decides who these small grants are going to go to. Some privacy law actually has provisions in it that say that people can opt out of having automated systems make decisions concerning them based on their personal information that they've provided. And so you would run afoul of those opt-outs if you were using AI to do something like that. So again, you need to look at, what are we using AI for? What's it doing with the personal information that we enable it to take a look at? The other big concern I have about AI is re-identification concerns. And that is, a lot of times people will say to a given company that has rightfully collected their information, please delete my information. And the company says, sure, we'll do so. And rather than just delete it, they do take out everything that identifies a given person, but they want that information in an anonymized form. So it's no longer personal information, but it's still information and data that they can use for other purposes. Maybe they're using it to determine the nature of their donors, certain characteristics about their donors as a whole. And so they have de-identified that information. It's now anonymous. It no longer identifies any given person. And so they've complied with this request that the person sent in to be forgotten. AI can actually take that information that's de-identified and through, well, magic, if you will, re-identify the person. It just figures out who this person is and may give you that information back. And so now you are in violation because somebody asked to be forgotten. You told them that you have deleted everything, and nope, now you have their information again. You know who they are. And, you may not know about it, but it may be the case. So that's a big concern that's out there with AI. It's just such a powerful tool, and we really haven't seen everything that it can do. And we know there are some unintended consequences out there like this that could trip us up down the road. So what do you look for to protect against something like that? Well, right now I'm seeing your best protection as first going to the terms of use that comes with that AI system. That is trying to get, especially if you're getting a paid program that you're using, negotiating in some protections against this kind of thing to make sure that you're not going to end up liable for such an unintended violation of somebody's rights. And then the second is, and this is again working with the provider, just limiting the reach of the AI system. You can limit what information the AI system that you're employing goes in and uses. And if you keep it out of things that you want to make sure that don't cause problems for you, then limiting it and keeping it out of those things will help a lot. The hard part about that is you really need to understand your data, how it's housed, how it works. This is well beyond the ken of a lawyer, but IT professionals specialize in this kind of stuff, and you need to have serious professionals working on this to be able to control and marshal your data.
Can you talk a little bit about the mechanisms that kind of help with gatekeeping, like the CAPTCHA tools and things like that? How does that fit in?
So what we're talking about here is you also have to be concerned that you don't want AI systems necessarily to be able to come and crawl your site and take information, especially donor information. It may not be through your site. They may be able to get into your system through your site or otherwise, and you don't want them scraping information, personal information about your donors. You can see how that caused some headaches and some upset people. And so how do you do it? Well, there are some ways in place now. And again, this is where you need an IT professional. But a couple of things that we've seen being used are, first of all, there's a thing called a robots.txt file, and you put that in the root directory of your website. And all that is it's kind of a signpost to crawlers that says, hey, don't copy this stuff. Sounds great, sounds perfect. The problem is it's completely voluntary.
Yeah, it's a gate without a latch.
That's exactly right. And there are many systems, I'm not going to guess at whether it's a majority, but there are many systems that would respect that. There are some that wouldn't, and there are always bad actors. That's not going to stop anybody who wants to do it, regardless of your wishes. So the second way is what's called a non-index meta tag that's in this heading section of your web pages. And that tells AI systems not to index the page. The problem is, again, this is more of a voluntary adherence model, so it doesn't get you too far. The next gatekeeper is the one you mentioned, which is a great one, the CAPTCHA, or a similar mechanism. By the way, I never knew what CAPTCHA stood for. I learned recently that, I thought it was something having to do with capture. I didn't really know it, but apparently it stands for Completely Automated Public Turing Test to Tell Computers and Humans Apart.
Okay. Somebody worked a long time to put that string of words together.
Exactly. It sounds like a law, the CAPTCHA Act, I could see. But at any rate, it can keep AI from collecting information from your site. But AI almost surely will overcome this gate at some point, and it may have already. Things change so fast, and AI is so powerful that at some point, it's unlikely that CAPTCHA is going to keep AI out.
Well, so I guess kind of my takeaway as I think about this from the nonprofit manager perspective is there's two sides to the coin. One is, how do I protect my information, my clients and donor and employee privacy and the things that I've got on my website that face the world? How do I protect those things? And then the flip side is, should I even be using AI? And if I am, what kind of guardrails do I want to put up? I can imagine the fundraising department, the development professionals, it could be a great tool for trying to find stuff. And the program people, this could be a great tool for deciding among competing proposals. And similarly, and right now it's just a toy that everybody's playing with. So some management policies and some understanding about guardrails we need to put in place. Right now, I don't know that we have any answers, just issues and things to worry about.
I think that's exactly right. It's going to take some time before we have answers. I think when I talk to clients about this, I generally talk to them about kind of trying to play it safe, kind of safe behaviors. What are you using AI for? How are you using it? What data is it collecting for you? Just being aware more than anything, because it's your best protection, I think, is going to come from truly understanding what you're doing with AI. It is a phenomenal tool. It's going to create some fantastic tools that are incredibly beneficial to nonprofits and for-profits alike. But at this point, it's like you said, we're all having a good bit of fun. As it gets more serious and as we use it for more, we're going to need to know more about the unintended consequences. And we're going to learn that as we go.
So I think that's a great way to wrap up this episode. Thanks again, Nate. I'm sure this episode will be really helpful to a lot of nonprofits and a lot of people in this space thinking about how and when to use these tools. Thanks for joining me, Nate.
Thank you, Cynthia. Great as always to chat with you.
And we'll do an update in a year from now and see how much of what we predicted as being a problem actually is and what the new ones are.
Fair enough.
Listeners can check out show notes for links to more resources. In particular, our episodes 20, 26, and 27 on copyright issues, nonprofit websites and terms of use, and privacy policies for more from Nate and myself on those topics. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.